Top legal developments, March 6, 2026. Deep dive analysis. 1. Nationwide employment law shifts. Key changes by mid-2026. Several U.S. states are implementing significant employment law changes that employers nationwide must heed. These new laws, in California, Colorado, New Jersey, and Washington, impose fresh compliance requirements and carry the potential for litigation if employers fall short. Below, we provide background and implications for each jurisdiction. California, Workplace Know Your Rights Act, SB 294. California's SB 294, known as the Workplace Know Your Rights Act, adds new employee notice and emergency contact requirements. Employers had to distribute a new Know Your Rights notice in multiple languages by February 1, 2026, and by March 30, 2026. They must allow all employees and new hires to designate an emergency contact person. Uniquely, the law asks if the worker authorizes the employer to notify that contact if the employee is arrested or detained by law enforcement or immigration authorities. This provision, prompted by concerns for immigrant and worker rights, means HR departments should update onboarding forms and policies now, providing clear opt-in forms for emergency contacts. Implications: employers need to train managers and update protocols to comply with SB 294's deadlines or risk state enforcement. Noncompliance could lead to labor agency penalties. Conversely, robust compliance, circulating the notice and gathering contacts, helps avoid lawsuits and shows good faith in protecting workers' rights. Nelson Mullins. +1. Nelson Mullins. Colorado Anti-Discrimination in AI Law, SB 24-205. Colorado is rolling out a first-of-its-kind law governing AI and employment. Senate Bill 24-205, the Colorado AI Act, takes effect June 30, 2026, after a legislative delay for further refinement. The law requires any employer that develops or uses high-risk AI systems, such as algorithms for hiring, promotions, or other significant employment decisions, to exercise reasonable care to prevent algorithmic discrimination. Under SB 24-205, employers must implement an AI governance and risk management program and conduct annual bias impact assessments of their AI tools. They also must provide notice to employees or candidates when AI is used and offer an avenue for human review of adverse automated decisions. Enforcement: the Colorado Attorney General can treat violations as deceptive trade practices, with civil penalties up to $20,000 per violation. Implications: employers using AI-driven HR systems should act now, inventory their AI tools, audit for bias, and establish oversight policies in order to avoid regulatory investigations or discrimination lawsuits once the law is active. Law firms and in-house legal teams are advising clients to align AI practices with Colorado's standards, which reference NIST's AI risk framework. Given Colorado is the first state to impose such AI rules, it may set a template. Non-compliant companies could face not only fines but reputational damage if their AI systems are found biased. Nat Law Review. Rocky Mountain Employers Blog. +1. Rocky Mountain Employers Blog. New Jersey Family Leave Act Expansion. A 3451/S2950 New Jersey enacted sweeping amendments to its Family Leave Act, NJFLA, effective July 17, 2026. Signed by outgoing Governor Phil Murphy in January 2026, the law dramatically broadens coverage and eases eligibility requirements. Notably, the employer size threshold for NJFLA coverage will drop from 30 employees to 15+ employees as of July 17, 2026, and will further phase down to cover employers with 5+ employees by 2028. At the same time, employees will become eligible after just 3 months of employment, 250 hours, instead of the previous 12 months/1,000 hours requirement. Leave rights. The NJFLA will continue to provide 12 weeks of job-protected leave for family caregiving or new child bonding. But a groundbreaking change is that job protection is now extended to an employee's own serious health condition in certain cases. For the first time, If a New Jersey employee takes leave and receives temporary disability insurance, TDI, or family leave insurance benefits for their own health issue or pregnancy, the employer must reinstate them to the same or equivalent position upon return. This fills a gap. Previously, NJFLA did not cover a worker's own medical leave, unlike the federal FMLA. Impact and compliance. Over 400,000 additional New Jersey workers, including many at small businesses, will gain leave rights under these amendments. Employers newly covered in 2026 need to update their leave policies and handbooks immediately to reflect the lower thresholds and expanded benefits. HR systems must be adjusted to track eligibility after 3 months, and managers should be trained on the new reinstatement obligation. Failure to reinstate could trigger wrongful termination claims under NJ law. Given this is described as the most consequential expansion of NJ family leave in history, we anticipate a surge in compliance costs and potential litigation. If employers mistakenly deny leave or retaliate against employees exercising these rights, labor attorneys are advising businesses to prepare now by revising policies, training HR staff, and communicating the new rights to employees. Baker Danielson. EBGLA. +1. Baker Danielson. +1. Washington State Fair Chance Act Ban the Box Expansion. HB 1747 Washington is strengthening its Fair Chance Act, which regulates how employers use criminal background information. The amended law takes effect July 1, 2026 for employers with 15 or more employees and will apply to smaller employers less than 15 employees by 2027. Under the new rules, covered employers can no longer inquire about an applicant's criminal history until after making a conditional job offer, reinforcing the ban the box practice. Moreover, employers are prohibited from taking any adverse action, like rejecting, firing, or demoting, based on A. Arrest records that did not lead to conviction, B. Juvenile convictions, or C. Any adult conviction unless the employer can show a legitimate